Welcome to MSL Presents A Question of Law. Thank you for joining us. This program is brought to you by the Massachusetts School of Law and is shown nationwide. In several states, the legality of single-gender classrooms, health clubs, and social clubs has been challenged with differing outcomes based on local state law. There is also a growing movement in support of a return to school solely for women or men. Query: are times so different, or are we so desperate that a return to segregation by the sexes and separate facilities is now the answer? On the other hand, is separate but equal always a bad thing? Joining me at our town meeting on separate but equal gyms, golf courses, and sports are Janet Durcher, attorney for 9 women golfers who successfully sued the Haverhill Golf Club for denying them equal access to tee times, to tournaments, and to premium memberships. Welcome. Cindy Curley, general manager of Orchard Hills Athletic Club and a former captain of the U.S. Women's Olympic Hockey Team. Cindy, thanks for joining us. Attorney Constance Rudnick, a professor at the Massachusetts School of Law, where she teaches constitutional law and many other courses. Connie, thanks for being here. The co-host for today's show is Michael L. Coyne, the Associate Dean of the Massachusetts School of Law. And I am Diane Sullivan, a professor here at MSL. Everybody, thanks for joining us. Connie, let's begin. If you would tell us about the Pennsylvania decision that permits all women health clubs.
Well, as you indicated in your introduction, Diane, most, if not all, of the court decisions on health club facilities and sports facilities are decided under state law because most of them are private and therefore are not subject to the constitutional prohibition on sex discrimination. In the Pennsylvania case, the Pennsylvania privacy statute has what is known as a consumer preference exception. And if the individual facility can demonstrate that the users of that facility, in order to protect their privacy, want to have a gender-based facility, then the Pennsylvania state law will permit that to occur, and that's what happened in the Pennsylvania case.
Thank you, Connie. One of the reasons that separate but equal has been regarded as legally acceptable in a number of the cases revolves around that degree of intimacy, as Connie Rudnick has suggested. For example, there is no one that challenges the right to a private bathroom in a public facility or a private shower. Now, what I'd like to ask the audience, and I'll turn it over to Mike, is whether the audience believes that there should be private health clubs solely for women, because health clubs are the equivalent in some situations as bathrooms and showers. Mike?
Thanks, Diane. So the question for all of you folks is, should there be separate health clubs, separate for men, separate for women, or as some of you would advocate, if there's going to be a separate club, it's female only? Could you tell me whether those of you, by raising your hands, would prefer separate health club facilities for men and separate health club facilities for women? There's about a handful of people only. Why would you advocate for separate health club facilities?
I just think that in today's society where fitness is such an important thing, that perhaps not necessarily for the younger generation, but the older generation of people who want to work out, they feel much more comfortable in that type of an environment, and I think it should be allowable under the law.
And then you would say then, though, that men could have their own health clubs as well, in which we could exclude females from.
Well, I suppose you would have to at that point, but I don't necessarily see that the same reasons apply, where women tend to be a bit more inhibited, especially in that age range where it would be warranted. I suppose you'd have to, but I wouldn't necessarily advocate for that position.
Does anyone else have views they want to share with respect to whether it is appropriate or legally permissible as to whether we should have separate health club facilities? Is there a demand? I mean, it doesn't seem like, in asking you folks, that there's any real significant demand where a business is going to make much money in the event that they decided to go either single sex or stay coeducational.
At first, I would say a hesitant yes as to whether you should allow single sex facilities, but do you not start sliding down a slippery slope? For example, can there be single sex restaurants? Because, for example, women are more inhibited about eating in public, perhaps. When do you draw the line? Assuming that some were, where do you draw the line as to what facilities are permissible because of their intimacy and which are not?
Well, Diane, that's a legitimate question. If we're going to do it for sex, what about race? What about religion? What about all the rest of it? I mean, is there an answer from one of our attorneys on where we would draw the line then?
has had to look at this question in Massachusetts. In the case of Forster versus the Back Bay Spas, Inc., which is a Superior Court decision in October of 1997, the court did look at it. Now, an interesting thing is the Back Bay Spas admitted that they were a public accommodation, which means that despite the fact that they were a private health club, they admitted that they drew from the public in general for its membership. And it was not selective in membership. You need not be grandfathered about 3 generations in to become a member of this club. So it qualified as a public accommodation under the statutes for discrimination. But then they raised the question of privacy. Do people have a right while they're working out, the right of privacy? And you're having these two issues clash. And the court said that because of the fact that when people are working out, they are doing so in a clothed fashion, their privacy is not so extreme as what you can get into with the slippery slope of when you start to say, we're going to allow it in this situation, but not in this situation. We're going to allow discrimination here, but not here. But they did leave kind of a little door opening that said, if you can show me that your privacy rights are so extreme because of this club, then maybe they'll reconsider it.
Janet, what about the situation where a woman has had a mastectomy or has struggled with obesity all of her life or has endured abuse? Isn't the privacy interest there much greater and therefore justifies having all-women health clubs?
If your club was going to be limited to people who were dealing with cancer, boys or girls, men or women dealing with cancer, because you can't tell me that men who are undergoing cancer treatment are going to be feeling less about their bodies or more about their bodies than women, then yes, you could probably, that's where I think the court is giving you that little opening to be able to say, show me such an extreme privacy question that we can then put it against the public accommodation question, the two constitutional issues or the two laws, and the weight is going to fall higher on privacy.
Diane, I think part of my problem is what do you do at some place like the University Club, which has a health club but also has a restaurant and a variety of other things. One of the reasons that in Boston the effort was made to eliminate single-sex clubs was because these kinds of clubs were seen as the location where the power was being brokered. And if they were men-only clubs, then the power was being brokered by only men, and women were being excluded from the location. So where do we draw the line? If it's Cindy's club, where all she has is a juice bar, that's fine. But if it's a health club which offers the same facilities but happens to be part of a larger facility where men go to refer each other cases and do business deals, then that's not. I mean, I think Todd's slippery slope not only goes to the location, but just to where the health club is located itself.
Cindy, let me ask you, in your experience, you run a co-ed facility. How do you deal with the self-consciousness that some women feel when exercising? I mean, that is one of the reasons that many courts have found permissible single-sex facilities.
That's a good question. I think it's important to point out, as Janet did, that it's not really just a women's issue. It's also a men's issue. As more people are getting involved in wellness and health, there's a lot of, have a lot of medical conditions. The onus really comes back to the athletic clubs to design facilities and programs that are appropriate for all sorts of different conditions. For example, if you're dealing with a predominantly early morning senior population, you're going to have a type of instructor that's most appropriate for that type of class in an appropriate setting, making sure that you have the privacy of locker rooms, that your staff is appropriate to deal with all different types of age groups and conditions. Some clubs I know have started putting women's only centers within their clubs. And the problem that they've faced and the challenge is, quite frankly, that you have a male that's had a radical surgery or what have you, and maybe you have somebody with a disability that's male that says, well, wait a minute, I'd like to have some more privacy too, so now I'd like to go in there. And then where is the cutoff point as far as, what qualifies for privacy or what doesn't? I really think that, the consumer needs to do a good job of looking at the type of marketing a club does. I mean, we need to market better to a broader age group. We need to develop facilities that are more appropriate to the type of audiences that we're looking for, and train the staff to have early intervention into any issues that come about. And for all the legal reasons, obviously that's prudent, enforcement.
Before we go back to Mike in the audience, let me ask you one final question. One of the chief complaints of women in a co-ed facility is the harassment that they feel, or the ogling that is done by men. How do you deal with that type of a problem, and do you deal with it? Do you remove the guy from the facility?
Unfortunately, I think that that's a reality, and I think anybody would be sort of deceiving if they didn't say in the club that does happen. And part of it is staff training. It's staying on the staff constantly. It's educating every new employee about it. And yes, there are definitely times where a lot of it's lack of communication. Somebody feels they're being flattering, and the reality is that that's not quite really the way it's taking. And a lot of times you can just discuss it with the member privately, and it's resolved. Sometimes you need to take it to the next step, and we have had to ask a couple people to leave because of that issue. And I think that it's important that we make the facility comfortable, and it goes both ways too. It's the same thing in life. It's not always the male. I mean, sometimes it's female, what have you. But we really have a responsibility to our membership to ensure that it's comfortable, and it really has to be hammered home constantly.
Thanks, Cindy. Mike, back to you.
Well, the question that still remains is that if very few of you would join an all-female or an all-male health club, and Cindy, I guess it's maybe a question better put to you, is there a market for it then? If we look in the audience, we ask folks how many would join, and we have very few people that would join, can you make a business out of 5 or 6 people?
I hate to speak for every business, but you're really locked into catering to a certain population. And I think, the other thing that happens is you have the stigma of, well, when I get in shape, I'll join an athletic club. So what happens if you join a women's only club because maybe you're a little bit out of shape and uncomfortable? Now you've succeeded in your goals and you're in shape. Now what happens? Now you say, well, geez, now I'm ready to graduate to the co-ed facility. So I think that there's a lot of business realities that you need to face.
There is definitely an issue that women feel upset when they become harassed, but then there are also many women who are upset that they are not given equal attention, and that men aren't paying attention to them, and they leave feeling with very little self-worth. And those are the people too that maybe don't come and speak up or make issues, but are affected very much by what happens at the gym or at the university or whatever. But like a facility like West Point, they worked very hard to keep women out because they felt they were superior. So I think the issues are completely different. I mean, women want to be separate so that they can build their self-esteem. Men want to be separate because they want to keep feeling elite.
We have to take a brief break, but and hopefully we'll be able to address that. And the underlying issue as well is that somehow it's inappropriate for men to want to have separate facilities, but it's completely appropriate for women to have separate facilities. Perhaps when we come back from the break, we'll be able to discuss that.
I don't know if you remember me, but I'm your lab partner in science. Anyways, I was wondering if you'd consider dancing with me.
Yeah, I would.
Really? You'd dance with me?
No, I said I'd consider it. Then I'd say no.
Hi, I don't know if you know me very well, but...
No, thank you.
I'm not much of a dancer, but...
No.
I wouldn't blame you if you said...
No.
Would you like to dance with me?
If at first you don't succeed, you're pretty normal. From the Church of Jesus Christ of Latter-day Saints.
A baby changes everything. It turns a couple into parents. Your parents into grandparents. your brothers and sisters into aunts and uncles. A baby changes how you invest and do your taxes. A baby changes what you buy, the way you drive your car. Everything. And while change is good, usually, you can always use a little help. That's why the free Consumer Information Catalog from Pueblo, Colorado offers you more than 200 free and low-cost federal publications. Just call toll-free 1-888-8-PUEBLO and help is on the way, even if you don't have a baby.
Welcome back to MSL Presents A Question of Law. We're here discussing separate facilities for women with respect to golf courses, gyms, and separate women's sports. Janet, tell us about the Haverhill Golf Course decision where I understand the court ordered $1.9 million to be awarded to women because they got less advantageous tee times and were denied playing in certain tournaments.
Well, there were a number of different factors on that case. One of the main factors was that until 1990, women could not apply as primary members. So 80% of the women there, or 99% of the women there, over 80 women, were locked into these limited memberships. They also had no rule for transferring. So once you were a limited, always a limited. You could not transfer to become a primary unless you wanted to completely reapply as if you were a new member off the street. As a limited member, you could not golf during prime times. Take your mind back to the 50s, pretend you're a homemaker, and then you could golf during pretty much 12 to 2, or pretty much any time men didn't want to golf. Saturday afternoons in the heat of the sun, men could actually go out and golf 36 rounds before a woman could golf. Women stood on the tee, an empty tee, waiting for the clock to chime a certain hour for them to be able to go out and golf. And our 9 plaintiffs went out and tested this over and over again because they tried to put in a rule that said the pro had discretion. Well, they discovered that the discretion was for the pro to watch the clock until they were allowed out. In addition, so the women could not become primaries, and then they could not golf during primary times. Now, if you were a man junior, you could, which meant you were under 21 years old. You could go out and golf during primary times. If you were a social member, you could go out, or if you were a male guest, you could go out. You're kind of getting the idea that only men were allowed on the course during primary times.
But aren't women slower?
Well, no, nor do they leave more divots. One of our 9 women was Karen Richardson, and she is the Massachusetts amateur golf champ. She can pretty much golf faster than about 90% of the guys at the Haverhill Golf and Country Club. So it wasn't an issue of slowness. Most of the women in our group of 9 could complete their 18 holes in the same amount of time that a man could. Now, in addition, in 1994, they did offer to allow some of the women to become primary. Some of the women took that. So now suddenly we have some primary women. However, those women aren't allowed to play in the primary tournaments because they suddenly became men's tournaments. So not only were they keeping them off the course during the prime time, now that the women are paying as much money, they could not even golf in the primary tournaments. So the jury kind of got the impression that discrimination was occurring to the tune of $1.9 million. Now, the nice part on top of it was we were also just awarded over $500,000, or close to $500,000 in attorney's fees, because if you take a discrimination case and win, you get to apply to the court for the attorney's fees you've accumulated. You just need to keep very careful billing, basically showing what you did throughout the whole case. We had 4.5 years worth of billing that amounted to about 2.5 inches that we submitted to the court, which showed every step of the way, everything we did in this case. The court went through it very carefully and took out very little of our time because they thought our billing was fair and reasonable on the case.
So now, Janet, you can take those winnings and play a lot of golf.
Well, as soon as the appeal's done, yes.
Connie, let me ask you a question. Do anti-discrimination laws apply to private clubs?
State laws do if the club fits whatever the parameters of the state law definition is. In Massachusetts, as Janet has said, it's called a public accommodation law. And if you operate a private facility in a public way, that is, you draw from the public, you open your, I think in the Haverhill case, they also rented out their banquet facilities. In other words, if you were just, you didn't have to be a member to get, have use of the banquet facilities. So if it's not purely private, and it is a public accommodation, then in Massachusetts that applies. And I would imagine that that's pretty much the same for other states.
Before we come back and talk with Cindy about separate but equal sports, women's sports, Mike, let's go to the audience and see if we have any reaction on the golf course case.
Some people did have an opinion, as you might guess, on how quickly or slowly women play golf and whether that's fair to the golf course if they're losing money because they have women playing golf at a slower pace than men.
You've offered some evidence, I guess, that would suggest that women can play as fast. I think that if you speak about somebody like Laura Davies, who is widely acknowledged to be the longest hitter on the female tour, and Tiger Woods, on the other hand, the biggest hitter on the men's tour, Tiger is still considerably longer, something like 30 or 40 yards on average. And just in the nature of things, if your first shot on a particular hole is longer, your next shot's going to be easier. And personal experience from my standpoint is that when we go to a golf course, a group of foursome, sometimes myself and another individual can reach a par 4 in one shot. So we're 2 or 3 of us might be on the green, whereas a group of women in front of us might take 7 or 8 shots to get to that same hole. As a result, I think 2 things happen. One, the men can get very frustrated and say, I've had enough of this course, I'm going to go home now. And secondly, what Mike pointed out is that doesn't the course suffer in terms of the amount of tee times that they can set up for any particular day?
Okay, I'm going to play devil's advocate with you. You're now 30 years older, and now you're an older gentleman on the course, but you still like your 7:30 tee time, which is the tee time that you and your foursome have always played. You're now not hitting the ball nearly as long or as hard as you used to. The golf course is made up of a wide variety of people. It is not made up of all young men who can take the ball and get a par on every shot. It is made up of older men, older women. It is made up of people who have handicaps of 50 down to scratch handicaps, which are handicaps of 0. So you can't say, I'm sorry, you people with handicaps of 50 and above, they would be fairer actually if you did say that. You people with handicaps above 18, whether you're male or female, you're not going to play until 12. What golf courses have done are said, I'm sorry, girls, you can't play. But boys, we don't care what your handicap is. You go out and you take the prime times no matter how slow you are. Bonus. So it's not fair.
Can I ask that? Would that be legitimate to say that anyone with less than a 10 handicap can play from 6 a.m. to noon, and then beyond that we would do it by handicap? Mm-hmm. And the second question would be, can we charge for the use of the golf course like we do at some ski areas and like by the hour? That if it takes you 4 hours to play, you'll pay X number of dollars, but if it takes you 6 hours to play a round of golf, you'll play X plus something.
Well, most golf courses, on the timing issue, most golf courses do have a rule that say you must complete your 18 holes within a certain period of time. Otherwise, you will be getting warning letters or you will be being scheduled for the time periods of the day which people find are the slower time frames. So most golf courses do address it that way. And I found in a lot of courses you have 5 hours to play, or I think the second or third time that you take more than 5 hours, then you do get assigned to a different tee time. So they have addressed it in that sense. As to the tournaments are run all the time, saying if you have to play in this tournament, you must have a handicap of this amount or under. Otherwise, you're not qualified to play in the tournament. So, you know, whether you say you can have a handicap of a certain amount, now, and then you have to set your handicaps based upon, saw a female raise their hand. They do set their handicaps. Women have different tees that they play from. And there is
that appropriate?
Yes, because there's a conversion for it. They have a computer program out there with a conversion that'll take, you know, I'm admittedly less strong than a guy playing golf.
Don't admit that.
Well,
Don't admit it.
I have
Okay,
a
Diane,
handicap
we're
of,
done.
I have a handicap of 50, so it's okay.
We need to go to our last topic because we're about out of time, which is separate but equal in sports. There doesn't seem to be a lot of debate about the fact that girls and boys are separate in sport. I think there ought to be a lot of debate, but there isn't. Now, let me ask Cindy a question. Should sport teams be co-ed in the name of equality?
Well, I think that, you know, traditionally I come from an ice hockey background, which was traditionally a man's sport and is now, I think, fairly coming to be somewhat equal. I think women should have the opportunity to try out for a men's team. And I think tryouts, a fair tryout is really what I think we should be looking for. And if they're good enough to play, they should, you know, be able to play on the team. I think having the opportunity to have women's teams is wonderful as well. There's a lot of colleges that now have Division I women's hockey, and that provides a lot of scholarship opportunities for women. It's a broader base of athletes. It's opened it up to be Olympic sport, and it may someday be, you know, a pro league. As far as whether a woman would ever play in the NHL, I think, again, it's, you know, they have the opportunities to try out, and if there's somebody that's good enough. I mean, Tara Mounsey, who played in the Olympics 2 years ago, was the men's high school player of the year. She was the best athlete in ice hockey for the state of New Hampshire, male or female, and she played on the men's high school team. So there is an argument that some women are definitely gifted, and she is a very strong, very talented athlete, and she's as bright as can be. She's at Brown on pre-med, so, you know, she's just a unique individual.
I want to thank everybody for joining us, especially our guests, and we hope that you'll stay with us for the next version of MSL Presents a Question of Law. Thanks for joining us today. Thank you.
This phone's taken.
Son, will this help you?
Maybe the last thing you would do for somebody should be the first.
Thanks. Hey, I appreciate it.
A message from the Credit Union Foundation and your hometown credit union.
When I was about 13, I had the worst paper route in the history of paper routes.
We worked out this great system. We'd start in the garage folding all those papers.
And just talk. That was my favorite part.
Remember Dad?
You know, I think he read more papers than he folded.
Oh, we were quite the team, weren't we?
Well, I still think you were driving a little too fast, Mom.
When you put your family first, you're building relationships that last. From the Church of Jesus Christ of Latter-day Saints.